for you to ask.
Well, I saw it came out because the new edition of Ganster was published in March, just as we went into lockdown. I suspect that disrupted things. But, yours is online as well, isn't it? Well, as well as being hard copy. So I suspect that would be people signing up to that.
It's quite practical, really. It's aimed at those who are used to, but not always involved in the process.
I had a look at it on the. I think there's a sample that's available just to have a look at.
Yeah.
And had a quick look. But we haven't, as a chamber's got a subscription to that planning element to do as we are. Maybe something to use that.
I tried to gather together the materials as well. The rules sometimes get forgotten. You know? Wales gets forgotten. And they're way ahead.
Really is a different jurisdiction there.
It is, yeah. Even times when you can't cross the border now.
didn't.
Sorry, I've got one. We haven't had an email to say it's going to be later than 11:30, have we?
No. feel butthurt in the matter of Gladman Developments Limited and specifically on state for housing communities and local government.
Thank you very much. Mr. Kimlin, Mr. Honey, I do apologise to you both and others for the delay, which has been quite unavoidable. Another hearing ran on, and we're starting late because of that, or later than we'd thought we might be able to start. So our apologies go to everybody involved, including council here, of course. But now we're ready to make a start again.
I'll begin, if I may, just with two short housekeeping points. Yes. I was asked towards the end of the hearing yesterday whether the my point that the departure from Hopkins Homes was intended by the bracketed words in footnote 6, but only for 11D1, whether that was on instructions, and I said it was. That's set out in my skeleton argument at paragraph 15. I've checked overnight as well, and I can confirm that the only change made to the new NPPF intended to depart from Hopkins Homes was the addition of the text in the brackets in footnote 6 for 11D1. There were other changes that were made in the new NPPF taking on board what had been said by the Supreme Court and in other cases, but nothing else that is, as it were, specific to Hopkins Homes in that sense. The second point was we were asked yesterday about the origin of the phrase the tilted balance. I've looked in case law at least overnight, and the first reference to it in case law at least is the Exeter City Council and Secretary of State case from 2015, decided by my Lord Justice Hickinbottom.
Yes, I knew about that. I was hoping you'd find a case before that. But I think that's the first reference. First judicial reference.
Yes, my Lord, that's right. And certainly, both my pupil and I looked overnight. That was the earliest one we could find. It was paragraph 15. And my Lord recognises the usage of it in practice. Yes.
Which, and I think Lord Carnwath does in one of the cases, says that it's used by practitioners.
Yes.
It does. But my own researches had yielded the same answer, actually. So it remains slightly mysterious. Somebody somewhere would claim ownership of it.
Yes.
But it's only a term of art used to mean what the policy says. I mean,
exactly. And I think
I'm not sure it is particularly apt, but that's what it.
No, I suspect it arose in practice simply because there was difficulty in referring to second bullet point, first indent, rather than now we can just say paragraph 11D2. So we're in the NPPF, which is supplementary bundle tab 9, and had reached, I think, page 121, which is paragraph 12 of the NPPF. Now, I've addressed paragraph 12 already, so I only need to say a little bit more about it now. As the court decided in Crane, paragraph 12 in my submission makes development plan conflict relevant to the paragraph 11D2 question, even on the narrower Crane approach. It does refer to with an up-to-date development plan, but I would make the point that, of course, paragraph 11D2 does not only apply where the plan is out of date. It applies also via footnote 7, where there's not a 5-year housing land supply, which could be nothing to do with the plan. It certainly does not mean that the plan is not up to date. Paragraph 14 does specifically relate to neighbourhood plans, but in my submission, picking up, I think, on the phrase from my Lord Justice Hickinbottom yesterday, paragraph 14 is not a dramatic shift in policy when you take it with paragraph 12. That reflects broadly the same scheme of approach to neighbourhood plans as was in the 2012 NPP. Now, in my submission, what paragraph 14 does is to describe the tilted balance exercise and make clear that allowing development which conflicts with a neighbourhood plan is an adverse impact for paragraph 11D2 purposes. So it assumes that that conflict is part of the 11D2 question, doesn't make it relevant, it assumes it, but goes on to provide advice for the weight to be given to conflict with the neighbourhood plan in the 11D2 balance. It tells us when conflict is likely to outweigh the benefit. So in my submission, paragraph 14 clearly confirms that development plan conflict is an adverse impact for the purposes of paragraph 11D2 and deals with the weight when we're dealing with neighbourhood plans. Over the page then we have paragraph 15, which is another part of the context on which I rely. And this refers, I accept under the heading of plan making, but it refers to the planning system being genuinely plan-led, the system as a whole, and it reinforces points that are made earlier, clearly in the context of decision taking in paragraph 2 and paragraph 12, for example. So, in my submission, NPPF policy is concerned with whether development is genuinely plan-led or not. And that would be a relevant impact or a relevant benefit for the purposes of the 11D2 balance. And development plan policy compliance is, in my submission, relevant here as well, because granting planning permission for development that's contrary to the plan could be an adverse impact for paragraph 11D2 purposes, especially if the development plan is recent. It would undermine one of the main planks of the NPPF, which is the system being genuinely plan-led. So if what we were looking at was a development which flew in the face of the spatial strategy set out in the development plan, then the development would not be genuinely plan-led, and that would be an adverse impact in my submission that could be taken into account in the 11D2 balance. And again here it's important to emphasise that 11D2 can be engaged where the plan is in fact up to date and where the plan is not any part of the reason why there's not a 5-year housing land supply. I've also referred in particular to paragraph 103 of the NPPF, which is page 144. And this talks about, it says, the planning system should actively manage patterns of growth in support of the objectives that are set out in paragraph 102. It says significant development should be focused on locations which are or could be made sustainable. And in my submission, the sustainable pattern of growth for any district, when one is asking about that, one would look to the spatial or the locational strategy that's set out in the development plan. The development plan would set out what the sustainable pattern of growth is for that particular district. So this NPPF policy objective is worked out, if I could put it that way, at a local level through the development plan strategy and the policies that implement that strategy. So in order to test whether the pattern of growth is supporting these sustainability principles, in my submission, it will be necessary in most cases at least, to look at the development plan, to test if the development meets that policy objective by judging how it measures up to the spatial strategy in the development plan. And if a development location doesn't comply with the spatial strategy in the development plan, in my submission it's most unlikely, therefore, to accord with this policy objective in paragraph 103. And we can see from the Corby plan in this case...
Well, before you go there, that last sentence makes it a requirement that it should be taken into account for plan making. And if it's a requirement that it's taken into account for plan making, is it a necessary corollary that it should be taken into account for decision making?
Yes, my lady, it says that in terms that it should be taken into account in both plan making and decision making. Yeah. And as a matter of practice as well, you would expect to find the plan telling you what the sustainable layout of development within a particular district would be. And I mentioned the Corby example, which is the supplementary bundle tab 1, the court doesn't necessarily need to turn it up, but that's a good example, and it relates, of course, to one of the decision letters in this case, where that contains a key diagram setting out the layout of development, and then a series of spatial policies, including the two critical ones, in this case, policy 11, policy 29, and it sets out the location of development by reference to particular transport corridors, infrastructure, and so on. And it is exactly, in my submission, where one would look to test if the development fitted with a pattern of growth that supported sustainability. And that, as we'll see, is a feature of the Corby decision letter. So those were the main parts of the NPPF on which I relied, but given how the appellant now puts things in relation to Crane, there are a number of other parts of the NPPF to which I draw the court's attention as to how it works more generally. So perhaps the court in the supplementary bundle could go please to page 131. This is related to housing. And I've selected some examples that are more directly related to the kind of case we're dealing with here. But this sets out in paragraph 59 a policy objective to boost the supply of homes, but to as well meet the needs of groups with specific housing requirements. So that's the policy objective in 59. And then in the first line of 60, it tells us that the number of homes should be set out in the strategic policies. That, of course, is the development plan. In 61, first line, it tells us that within this context, the size, type and tenure of housing needed for different groups in the community should be assessed and reflected in planning policies, in the development plan, of course. And 62, where a need for affordable housing is identified, planning policy should specify the type of affordable housing required.
To an outsider, just explain to me, if you will, Mr. Honey, what's the difference between a strategic policy and a planning policy?
A strategic policy is one which would set out the high-level strategy for a plan, the distribution of development, for example, the number of homes or the amount of employment floor space that would need to be covered. So a strategic policy is a type of development plan policy, but it's one that deals with high-level strategy rather than matters of detail.
Whereas the planning policy is the matters of detail.
Well, both are planning
but
policy, but the higher level one's the strategic policy. And if
So, for example, you'd have, on housing, you'd have a strategic policy to allocate so many dwellings in that particular plan, and then that would be a strategic policy. Then the working out of that in terms of specific allocations on particular sites around the district or borough would be within this rubric.
yes,
and other planning policy.
yes, my lord, that's right.
It may be of some help to look at paragraphs 20 to 23, page 1, 2, 3.
Yeah.
thank you very much.
Thank you very much.
And we also have, just along the same lines, paragraph 65 of the NPPF, first line, establish a housing requirement figure for the area which will be done in the local plan. And then similarly, 73, about 6 lines down, talks about 5 years' worth of housing against the housing requirements set out in the adopted strategic policies.
73.
73, my lord, yes.
Yeah.
That's the requirement for 5 years' worth of housing against the housing requirements set out in the strategic policies. Then
So does
another
that
example.
does that match up to the old 49
In part, yes. My
part? Yes.
And then another example is paragraph 78, which deals with rural housing. At the bottom of 135, it says to promote sustainable development in rural areas, housing should be located where it will enhance or maintain the vitality of rural communities. And then it says planning policy should identify opportunities for villages to grow and thrive, especially where this will support local services. So we've got a policy objective in the first sentence and then reference in the second sentence to planning policies identifying where the vitality, as it were, is required. So all of those examples I've just shown the court are ones where in my submission to test whether the NPPF policy objectives would be complied with by a development proposal, you need to look at the development plan policy to judge whether the development delivers what's needed and how weighty the benefit should be in the 11D2 balance. You have to look at development plan policy. Page 14.
Sorry, you said to see how weighty the benefit or adverse impact is.
Yes, Miley, to judge whether the development delivers what's needed and if it is a benefit, how weighty that benefit should be in the 11D2 balance, you have to look at the development plan policy to see whether it is providing housing of the type needed, for example, or housing in a village where it's needed to support vitality. So the NPPF sets out the policy objectives and then expects the local, as it were, representation to be set out in the development plan. It's that which you use to judge whether in a local area the policy objective in the NPPF is actually met. Page 143 of the bundle, this is one of the examples in paragraph 99 identified by the Supreme Court in Hopkins Homes. You can see the first line of 99, the designation of land as local green space through local and neighbourhood plans. So you need to look to the development plan to see whether the development would affect local green space. Page 150, another similar example of a policy objective and then local working out. Paragraph 122 says planning policies and decisions should support development that makes efficient use of land. So that's the policy objective. And then paragraph 123, it's just over the page, at A, says plans should contain policies to optimise the use of land in their area. It goes on to say it should include the use of minimum density standards for city and town centres and other locations that are well served by public transport. And a similar wording in B, the use of minimum density standards should also be considered for other parts of the plan area. So we've got a policy objective in 122, the efficient use of land, but you have to look to the local plan to find the measures, as it were, to test whether that NPPF policy objective is being met. You judge whether the use of land is efficient or not by reference to what's been said in the local plan. Another example, page 152, this is design. We've got a policy objective in 124. Second sentence, good design is a key aspect of sustainable development. But it then goes on in the next paragraph to say being clear about design expectations and how these will be tested is essential for achieving this.
Sorry, which paragraph?
124, my lord.
Yeah, sorry.
So it sets out the policy objective, good design is a key aspect of sustainable development, and then goes on in the next sentence to say being clear about design expectations and how these will be tested is essential for achieving this.
And you say that would be done in the plan?
Yes, my lady. We see in 125, it says plans should, at the most appropriate level, set out a clear design vision and expectations. The next sentence refers to design policies. The last sentence refers to neighbourhood plans, playing an important role in identifying the special qualities of each area and explaining how that should be reflected in development. And then there's a similar reference over the page in paragraph 130. Policy objective, refuse permission for development of poor design that fails to take into account any local design standards or style guides in plans. Then the next sentence, conversely, where the design of a development accords with the clear expectations in plan policies, design should not be used as a reason for refusal. So again, we have policy objectives, but you need to look to the local plan for the local design expectations to test whether the NPPF policy objective is being met by any particular development. Then over the page we've got chapter 13 on Greenbelt. The Supreme Court again identified Greenbelt as one issue where you need to look at the local plan. Greenbelt is defined in development plan policy as local green spaces, but other things are as well. So if we go on to 162, there's a policy in paragraph 167 on page 162, which relates to coastal change management areas. That's another example. Paragraph 167, plans should identify as a coastal change management area any area that's likely to be affected by physical changes to the coast. So like Greenbelt, like local green space, another example where you need to look at the local plan. Over the page, there's the policy for the natural environment at 170. Paragraph 170A talks about designations of sites of biodiversity value and refers to them being identified in the development plan. Then paragraph 171, second line refers to locally designated sites. Then again, the next page, 174A, talking about biodiversity. So the plan should identify, map and safeguard components of local wildlife-rich habitats, including locally designated sites of importance for biodiversity and local wildlife corridors. So those are another examples of things which the NPPF seeks to protect in policy, but where you need to look at the local plan to identify what it is that's being protected.
Yeah, just to fit this together in a slightly bigger context. As I mentioned to you yesterday in a case we were hearing last week, we were looking at paragraph 172. Just reuniting ourselves with paragraph 11 again. We're not dealing in this case, of course, with 11D1, but 11D1 has footnote 6, and footnote 6 refers to a number of policies, including policies for AONB and Heritage Coast, which are encompassed in 172 and 173. So they find their place there. Is that right?
Yes, but though things like national parks, areas of outstanding natural beauty, are designated outside of the development plan system under other legislation.
Well, yeah, that's why we have to be slightly careful as we go through to make sure that where we are actually, because of course footnote 6 has that now deliberately entered proviso.
Yes. So there are some things, and I'm attempting in the context of 11D2 to identify those policies here as examples, as per Crane, where the NPPF directs you to the development plan to test whether NPPF policy is complied with.
Yeah, I mean, if we just go back to Crane, I don't want to take more than a moment on it, but if you go to paragraph 74, I appreciate you mentioned other passages, as did Mr. Kimblin. very foot of page 197. I'm referring, of course, to paragraph 14. And specifically the weighing of any adverse impacts against the benefits. That's the context for what I'm saying there. And right at the foot of the page, it does not prevent a decision maker from giving as much weight as he judges to be right to a proposal's conflict with the strategy in the plan, or, in the case of a neighbourhood plan, the vision.
Yes.
What do you take from that?
Well, that is a specific reference in terms of the vision to the nature of neighbourhood plans, but the
It's not just that.
reference is more general because it's referring to strategy in the plan, which is referring back to the earlier part of the paragraph, which relates to development plan policy. So that, in my submission, even approaching Crane on a narrow basis, I'm okay with the decision letters in this case because of the elements of the NPPF, but the more general point in relation to Crane is that it endorses the general proposition that development plan policies generally are relevant to the tilted balance exercise.
Perhaps all I'm saying is let's approach Crane on a Crane basis.
I take that point, yes. The reason for attempting to go through these policies in particular was to make good the point I made yesterday about references to the development plan being pervasive throughout the NPPF.
Yeah.
And this is the point I think it comes back to in terms of it. You need to take a holistic approach. It's not sensible to try to divorce the two.
Mr. Honey, can I just ask something about that? If you took, let's say, 174A, which you were just on a moment ago, in the 2019 NPPF, if it didn't, if the decision maker was not entitled to look at the development plan, but could just look at the policy statement in the NPPF, how would the decision maker make a decision about the extent to which wildlife-rich habitats or ecological networks were protected?
It would be impossible in the case of local wildlife sites and local wildlife corridors because they're only identified in the development plan. You have to look at the development plan to see if one of those is near to the site, but also usually, I make the point usually, not always, the development plan would then say something about that site, what its important features are, what may be the features that are at risk of being harmed, those that are not in good condition, and so on. So you would expect the development plan not only to identify the area of land, but also the interests that could be at risk from a development. So in order to judge not only the existence of a local wildlife site, but the adverse impact this development might have on it, and the importance of that when one comes to think about the weight to be given to the adverse impact in the 11B2 balance, that would have to be informed, in most cases, by what's in the development plan.
We perhaps should remember, should we, that this framework is the work of its author, its governmental author. And the governmental author has taken the trouble to say what it has, is that right, in these various policies you've shown us. If your submission is right, and it is appropriate, sometimes indeed necessary, to take into account development plan policies, to understand how at local level policy has been translated faithfully or not faithfully into the development plan. Your submission in answer to my lady is you simply can't do it unless you look at the plan.
Yes, it would be unworkable.
And the governmental author of the policies is keen at paragraph 11D to make sure that when this whole exercise is being done, the decision maker pays attention to the way the government puts it in the framework, to ensure that the decision maker sharpens its focus on that point. Is that correct?
Yes, it's those things that are regarded as important as it were, by the national planning policy maker, but with much of the detail deliberately being left to local authorities to work out at a local level.
Right.
So the final example I was going to give
Yeah.
of this is page 170 and paragraph 197, which is another example similar to the local wildlife site, which is a locally listed building. It's a non-designated heritage asset, would include a locally listed building. So again, in order to understand what is a non-designated heritage asset and the importance of it, one needs to look at the local plan. We see that at page 181, within the glossary, we see reference that heritage asset includes, second sentence, designated heritage assets and assets identified by the local planning authority, including local listing. And there's also the penultimate definition on that page about biodiversity, refers at the end of it to locally designated sites, including wildlife sites. So that brings me then to my submissions on the context. And I flagged this yesterday, so I'll take it quite quickly. But in my submission, the policy in 11D2 must be interpreted in context, and there are two elements of the context here. One is the statutory scheme for the plan-led system, and the other is the policy document within which paragraph 11D2 sits, and that's the NPPF as a whole. So on the first of those, the plan-led system, my submission, the court should interpret the NPPF in the context of it being part of the statutory system, as interacting with other elements of it, not being separated from them. And in particular, paragraph 11D2 is subject to the two statutory duties, the duty in section 70 subsection 2 of the 1990 Act, and then the duty in section 38(6). And section 70 subsection 2 is important in my submission in particular because that makes the provisions of the development plan a statutory mandatory material consideration when dealing with the planning application. And one point of difference, if one looks at paragraph 11 of the NPPF, page 120, the supplementary bundle, with paragraph 11B1, 2, that we were discussing, the strategic policies point. One important point of difference when comparing B2 and D2 is that D2 is subject to those express statutory duties. B2 is not. The context for construing B2 is different. Even setting aside the debate we've been having about the strategic policies point. When one looks at 11D2, development plan policies are important statutory material considerations for dealing with the planning application, and they are the fundamental building blocks of the plan-led system. So in my submission, it's necessary to interpret paragraph 11D2 in the context of that plan-led system, even though there's no express reference in 11D2 to development plan policy, because there are those statutory duties that apply to that don't apply, for example, to 11B2. The second point of context in terms of taking the NPPF as a whole, as I hope I've just shown the court, compliance with development plan policies is relevant to compliance with the NPPF as a whole. And it's not just a couple of paragraphs that cross-refer, as it were, to development plan. It's pervasive in my submission that many parts of the NPPF make it clear that development plan policies can be relevant when considering adverse impacts and benefits against the policies of the NPPF for the purposes of paragraph 11D2. That, in my submission, is one reason why the holistic approach, as it was put yesterday, is attractive. So that's the context. In terms of how paragraph 11D2 works, I'll make 5 points, if I may, again taking them quite quickly in light of what was said yesterday.
Well, not so quickly that we can't get a note of them. I'm afraid I write rather slowly, so forgive me.
I will go more slowly now, my Lord, grateful for that indication.
Well, so that we get the main points, at least,
Yes.
accurately.
So the first point is that although 11D2 only expressly refers to policies in the NPPF, the wording does not confine consideration of policies just to the NPPF. In my submission, it could encompass other government policy documents, and in light of section 70, subsection 2 of the 1990 Act, should normally at least have regard to the statutory development plans. That's part of the statutory scheme. The second point is, because paragraph 11D2 refers to adverse impacts and benefits, whether something is an adverse impact or a benefit can sometimes only be judged by looking at development plan policy. So to take some of the examples we've just looked at, where housing is proposed, part of judging whether it's a benefit, and if so, how much of a benefit, is asking about the size, the type, and the tenure of the housing. Asking about the amount and the type of affordable housing. If it's in a rural area, asking whether the housing is needed for the vitality of a rural community. And of course, all of the examples that we looked at as to whether or not the development could affect something like a local green space, like a local wildlife site, or a locally listed building.
And just looking at the NPPF isn't going to tell you whether the size, type and tenure are consistent with policy or not.
Yes.
You've got to go to the development.
The development plan will tell you what's needed locally. And it may be in some areas family housing is needed. It may be in other areas starter housing is needed, for example. The third point is when paragraph 11D2 speaks about adverse impacts and benefits, in my submission that's not confined only to physical impacts and benefits. It could include policy impacts and benefits. So it may be relevant to ask, for example, does this development deliver something that is sought locally in development plan policy? Does the development plan say this area needs a new school? Does the development plan say that highway improvements are required that this development could deliver? And as far as harm is concerned, my submission, you can ask, does the development cause policy harm, an adverse policy impact, for example, by undermining the effectiveness of the plan-led system by proposing something like a large number of houses in the open countryside that flies in the face of the development plan spatial strategy, or if permitted would do something to undermine the credibility of the local plan. So policy impacts and benefits can be relevant as well as physical impacts and benefits, and that requires looking at the local plan.
Well, you say undermine the credibility of the local plan, but what about the credibility of the plan-led system?
That would be an element of it, my lord, yes, because it would undermine the local plan, which is a key plank of the plan-led system, which is at the heart of town and country planning.
Well, you've submitted it's at the heart of the NPPF as well.
It is, my lord, yes. My fourth point relates to weighing the factors in the tilted balance. And this is, in my submission, another example of where development plan policy could be relevant. So where the importance of an impact or benefit is recognised in the development plan as well as being recognised in the NPPF, so it's echoed in the development plan, then in my submission, a decision maker could give that factor in the tilted balance more weight because it's regarded as important locally in the development plan as well as nationally in the NPPF. Now that, in my submission, is not any kind of double counting, it's simply recognising that a factor, an impact or a benefit, is weightier in the tilted balance because it echoes or sounds in both national and local policy. There are things like conservation areas, valued landscapes that are recognised as being important in the NPPF, but if they were also recognised, a particular landscape area or a particular conservation area was recognised as being important in the local plan, that would lend weight in the tilted balance to the development's adverse impact or benefit to the setting of the conservation area or that landscape area. So the development plan in my submission could be relevant to weight as well as relevant to identifying adverse impacts and benefits in that balance. And then my fifth and final point is a general point, which is that when conducting the tilted balance exercise in paragraph 11d2, what precisely to take into account as an adverse impact or benefit, or indeed as relevant to weighing an adverse impact or benefit, but primarily matters for the planning judgment of the decision maker in the circumstances of the specific case. And that's because what we're dealing with is the application of policy in the NPPF in paragraph 11d2 to a particular set of factual circumstances. And the decision maker ought to be able to use their judgment to decide how best to go about that task in any particular case. And that comes back to Mr. Justice Holgate's point about applying the section 38.6 and 11d2 exercises separately or together. It's a judgment for the decision maker what is the most appropriate way to go about it in the circumstances of any particular case.
I mean, it seems to me there may be many ways of doing this lawfully, but there must be some ways which will be unlawful.
Yes.
I mean, that's probably an obvious public law point.
We come back then to the Supreme Court recently in the Samuel Smith brewery case that says it's really a question of public law irrationality. Correct. If a factor is taken into account when it was irrational to do so, or if it's been given weight by reference to a particular matter that actually it was irrational, that's the limit.
Or if it's not taken into account and it was a material consideration.
Yes.
I mean, there are some sentences in some of the cases which suggest there's no limit, but there is that limit, but that's just a public law limit.
Yes, I accept that.
To assessment.
Yes,
It's no
the public law irrationality limits will confine what can be done, but otherwise should be a matter for the discretion, essentially the decision maker, in any particular case.
Yes, I mean this is intertwined, or perhaps is the concept of the obviously material consideration.
Yes.
Some things are just so obviously relevant to the task in hand that it would be irrational stroke unlawful not to take them into account.
Yes.
That's not novel law at all.
No.
It has a very strong provenance in many cases we're all familiar with.
Yes. So those were my 5 points, and that then takes me, having dealt with the interpretation of paragraph 11D, specifically to this two-stage point, if I could put it that way, where the appellant says that paragraph 11D2 and section 38(6) must be applied separately in a sequential two-stage approach. Now, my submission, that's not necessary. We had in this case an agreed statement of legal propositions which summarises the relevant law. If I could ask the court please to go the supplementary bundle to tab 6. That sets out, that's the first page, page 37 of the agreed legal propositions. The bottom of page 38, there's a heading that relates to the presumption in favour of sustainable development. And then over the page, the top of page 39, we need to look, well, it's the end of 38. So it requires a planning decision maker to exercise a planning judgment within the balancing exercise mandated under section 38(6). So it is not an entirely separate two-stage process. We then have paragraph 13, which sets out agreement as to the operation of the NPPF's presumption in favour of sustainable development. And this draws on the BDW case law. I won't read all of paragraph 13 out, but it is in my submission important. So if the court maybe takes just a moment to look at paragraph 13.
Is that a summary of my summary in BDW?
It is, my lord, but it cross-refers to some other things. But importantly, it applies it to the 11D2 process. So it says it also holds good for applying the presumption in favour of sustainable development. So paragraph 13 is important, but also 14 over the page, which records agreement that planning is far from a mechanical process. It's flexible, not rigid or formulaic.
Yeah.
And then also in 17, the fact that a decision letter necessarily has to be written in a linear manner doesn't mean that a decision will have been reached by considering it in that stage-by-stage process. So in my submission, the appellant's contention that these two things, paragraph 11D2 and section 38(6), must be applied as separate sequential stages is unsustainable in light of that common ground, and in particular paragraph 13, which describes how the exercise is supposed to work.
I think Mr. Kimlin's submission was that you have to have a sequential approach, I think. Is your submission that you don't, as a matter of law, you don't have to have a sequential approach? A sequential approach may well be fine. But do you say that there may be circumstances, I won't try and posit an example because it'll fall apart, but are there some cases where it would be unlawful, some cases where it would be unlawful not to have a sequential approach?
I'm very reluctant to say never. So
no, exactly. Well, that's where I've got to. But
yes, and that's why we support what Mr. Justice Holgate said below, where he said effectively it is permissible to apply them together or separately, and it's a judgment for the decision maker in the circumstances of the particular case how to go about that exercise.
And I mean, conceptually, that's subject to the usual rationality boundaries, and so without thinking of an example, if that would be irrational, then that would be unlawful.
Yes, it would be possible for someone to seek to persuade the court that the facts of a particular case meant that it was irrational to apply them together or separately in a particular case.
You say that's fine conceptually, without descending to try and posit an actual example, which I understand.
Yes. I mean, the judgment, and it's in particular paragraphs 107, 108 and 110, the way it was described by Mr. Justice Holgate, is in my submission correct. I will see the two decision letters in this case in a moment, but the approach that the judge below set out in my submission doesn't conflate the two. It doesn't dispense with either element of these two balances. It recognises that there are two balances or presumptions and says it's permissible to apply them together or separately. It is in my submission enough that they are applied, as they clearly were in these two decision letters, and it doesn't change the substance of the tests as a point of principle, whether they're applied together rather than separately. That, in my submission, is a matter of judgment for the decision maker in the circumstances of a particular case, exactly how to go about it, in line with the case law summarised in paragraph 13 of the agreed legal propositions, but subject always to Wednesbury rationality as an outer limit, as it were, of that discretion.
The closest we get to this, I believe, certainly at the highest level, is in City of Edinburgh in Lord Clyde's speech. There is a passage that I've got in mind that we just ought perhaps to look at.
It's Authorities tab 5, and the most relevant is, I think, my lord, page 62 of the Authorities bundle.
Yeah, that's where I am.
Which is 1460. I suppose it starts at the very bottom of the previous page.
Yeah.
In my view, it's undesirable to devise any universal prescription for the method to be adopted, and it's that section that's been sidelined on page 62 of the bundle, A, B and C, through to the end of that paragraph.
Undesirable to devise any universal prescription. This is, I mean, he does deal with the two distinct stages. He deals with the point, actually, directly.
Yeah.
So perhaps we ought to pay attention to what has come from the House of Lords.
Yes, and the paragraph 13 of the agreed legal propositions I refer to because it applies specifically here, but that is in the footnotes, citing BDW trading, but referring also to City of Edinburgh, setting that out.
I mean, that's the law.
Yeah.
You know, unless the law is inadequately stated by Lord Clyde there, that's the law.
Yes. Was agreed in this case because that's the law, and in my submission, in light of that law, the argument that the appellant makes on this two-stage point is unsustainable. So that brings me, if I may, to the two decision letters in this case, which are towards the back of the core bundle.
Right, just a second. Right, let's clear the decks for a second. We put the authorities away.
Yes. Unless anything unexpected happens, all of the rest of my submissions will be by reference to the core bundle.
Right. The supplementary bundle goes away. And core bundle.
Yes, there's tab 21 in the core bundle for the decision letter.
Yeah.
The court has looked at these, so I'll take it as quickly as I can, but starting at page 320.
It would help us, or at least certainly me, if you could just identify, perhaps even before you start, if it's possible, what the truly salient passages are that one might expect to see in the judgment.
Yes, I think in particular it's paragraphs 7 and 8. 16, I think, is important. 30 and 31. And then 46 and 52 through to 56.
46.
and then 52 through to 56.
Yeah.
So I'll go to a few others, but those are my submissions.
So those are the really salient bits of it.
Yes.
That's very helpful, thank you.
So on page 320, we have the heading, Development Plan Strategy, in the middle of the page. That's there what the inspector talks about. And I'll go, if I may, to the middle of paragraph 7, where the inspector says the JCS, that's the Joint Core Strategy, clearly recognises development needs to be carefully managed to safeguard the intrinsic character and beauty of the countryside and to sustainably focus growth on the most accessible areas. The strategy was found to be sound and consistent with the framework by the examining inspector. Then in 8 moves on to refer to 2 particular policies that implement that strategy, and makes the point that the fact that there's conflict with those policies and the strategy is not disputed. The appellant contended that it was merely, as it were, black letter harm, but the inspector says that considerations of matters of accessibility and character and appearance at the very end of that page underpin, over the page, the recently adopted strategy. They are therefore critical in assessing whether it would be appropriately located. So that's the inspector setting up the importance of the strategy. We then go to paragraph 16, which is where sustainability in transport terms is set out. And this echoes repeatedly paragraph 103 of the NPPF. Talks about opportunities to maximise sustainable transport solutions, 5th line, actively managing patterns of growth, locating significant development in locations which are or can be made sustainable. That's reflecting the words of paragraph 103 of the NPPF. Then the inspector draws a conclusion at the start of 17. The proposal would be a significant development, and a central plank of sustainable development in the JCS is to minimise the need to travel and reduce car dependency by directing development to the most accessible location. So it's offending against a central plan of the JCS. And then an overall conclusion in paragraph 18, which again echoes paragraphs 102 and 103 of the NPPF, where it talks about choice in travel terms, cycling and walking opportunities, and so on. So that's the inspector's assessment of sustainability in transport terms. And then at 19, we see the heading Character and Appearance, where the council's case in relation to that issue was predicated on the spatial effects and the subsequent harm to the delivery of the strategy. So that's the first sentence of paragraph 19. So harm to the strategy is relevant as far as character and appearance is concerned as well. And then the inspector draws it all together on page 325 in paragraphs 30 and 31. Drawing everything together, any deviation from a strategy should not automatically lead to unsustainable outcomes. But in this case, the proposal would not be appropriately located, having regard to the JCS in terms of its location. And then it refers to the impacts of that, the need to travel, environmental harm, greenhouse gas emissions, and harm to the character and appearance of the area. And then in 31, the inspector says these are central planks to realising the overarching spatial vision of sustainable development, which the plan as a whole is seeking to deliver. So that's the relevant analysis, and it's drawn together on page 328, where we see the heading Planning, Balance and Overall Conclusion. So one point in particular I'd ask the court to note is the first sentence of paragraph 46, where the inspector records expressly a conclusion: the development is in conflict with the development plan when read as a whole. So a conclusion on development plan compliance is clearly stated. Then at the end of paragraph 46, reference to paragraph 11d2, noting before that, in the middle of paragraph 46, the reason we get there is because there's not a 5-year housing land supply. And it sets out in terms, at the end of 46, the 11D2 question to be answered. And identifies then in paragraph 52 over the page, second line, the development would conflict with the development plan's overarching locational strategy and perpetuate unsustainable travel, etc. So that is similar to Claimant in terms of identifying conflict with the development plan's overarching locational strategy.
Sorry, where are you exactly?
Paragraph 52, my lord.
52, yeah.
Second sentence. So there's an element, as it were, of policy harm, as I described it earlier, conflict with the overarching locational strategy, but then also the description of the physical adverse impacts, unsustainable travel, character and appearance that were identified earlier. In relation to the point that this applies when there's not an out-of-date plan, we also see in 52 the inspector reaching conclusions 4 lines up from the bottom. The shortfall in housing land supply is not significant, and making the point that the council is actively working and progressing delivery. Then over the page, I'll come back to paragraph 53 in the context of issue 2 or ground 9, but 54 mentions in the first line the plan-led approach to site selection, which echoes paragraph 15 of the NPPF. And then at the end of 54, the inspector says it's likely, in my judgment, to lead towards a distortion of the plan-led strategy, a distortion that would be exacerbated by the appeal proposal, which would result in a more dispersed and unsustainable pattern of growth. That phrase, pattern of growth, again echoing paragraph 103 of the NPPF. And then in 55, we get an answer in terms to the tilted balance question, the 11D2 question. The adverse impacts of granting permission would significantly and demonstrably outweigh the benefits when assessed against the policies and the framework taken as a whole. And then in 56, the inspector restates the conclusion about conflict with the development plan when read as a whole, and then does the section 38.6 balance. So we've got the 11D2 balance done in 55, and then the section 38.6 balance done in 56. So we've got, as it were, all the building blocks: conclusion on development plan compliance, conclusion on 11D2, and overall conclusion on section 38.6. My submission that there is nothing wrong with that. So the next decision letter, if I may turn to that, is the Uttlesford decision letter, which is behind tab 22.
Litch Green.
That's right, my lord, yes. And the key paragraphs in terms of reciting are probably confined in that case to, well, perhaps 66, because that's where we see the conclusion on the conflict with the development plan, and then also probably 72 and 73. But I'll go through the...
Sorry, just a moment. Just say again, I'm so sorry.
My lord, I think in terms of citing the key paragraphs, it's probably 66.
Yeah.
And then 72 and 73. Others are relevant, but those are the
Key ones.
So in this decision letter, on page 324,
Yeah.
the...
334, do you mean?
Sorry, 34, my lord.
Yeah.
So paragraph 6 of the decision letter, second sentence, the inspector again, because there's not a 5-year housing land supply, says this triggers the consideration of the appeal against paragraph 11D2. I'll return to that in the planning balance and conclusion section. And then again, 11D2 is mentioned in paragraph 8 as the fourth main issue, significantly and demonstrably outweigh. So the inspector's there setting out.
It just says 11D, but it means 11D2, doesn't it? In context.
In context, but there's also a need to consider the first leg of 11D1.
Yes.
And that's done in paragraph 72 of the decision.
Yes,
letter.
yes.
So I suspect that reference in 6 probably is to
To the
both
general
D1
11D.
and D2.
Yeah, so he's quite deliberately saying just D.
Yes.
Just before we pausing there, when I read this the first time, I just wanted to get the anatomy of it clear. He's got 4 main issues at 8. Character and appearance, setting of heritage assets, protected species, and then effectively tilted balance.
Yes, and what we've got in 8.4 is both elements of 11D. It's the clear reason point, or significantly
I beg your pardon, paragraph 11D. So just to get this clear then, character and appearance has got a heading above 9.
Yes.
Then heritage assets 23, which he divides up. And then he's got a heading other considerations at 50.
There's protected species.
Just above paragraph 44, my lord.
Yeah, protected species, yeah. So that's issue 3. Then my question was, where does issue 4 start? And that's other considerations, is it?
Issue 4 is 11D2,
Yeah.
which if you look at the end of paragraph 6 of the decision letter, the inspector says, I return to in the planning balance and conclusion section. And then when we look at the planning balance and conclusion section, it is dealt with in paragraphs 72 and 73.
Right, so other considerations is extraneous to issue 4.
Yes.
That's right, is it?
Yes. Decision letters will usually have a section headed something like other matters, where the inspector will sweep up other matters that have been raised beyond the main issue.
All right,
so I suspect that's what's done.
issue, to be clear, issue 4, as you read the letter, is dealt with in paragraphs 63 and following.
In particular, 72 and 73, but within that section, 63 onwards.
Thank you.
So the first substantive paragraph, just to note please, is 22, where the inspector notes that the proposal would have a significant adverse effect on the character and appearance of the area and conflict with policy S7.
Yeah.
And then the conclusion on the heritage assets point is page 340. Where the inspector in 42 finds harm to listed building settings and the conservation setting. And that's relevant because of what then is said in 43. There's reference first to the framework and less than substantial harm. But in the third line, it's made clear that that applies to listed buildings and the conservation area, because they're all caught up in the framework policy. But if one looks at the end of 43, the local plan conflict for ENV2 only relates to the setting of listed buildings, because there's only a development plan policy that relates to listed buildings. There's not one that relates to conservation areas. So if we then move to the planning balance and conclusion section, paragraph 66 on page 343, the development plan policies are cited, and then at the end of paragraph 66, a conclusion reached on compliance with the development plan. And that's relevant, of course, for section 38.6. It's also relevant, of course, for paragraph 11C of the NPPF, but a clear conclusion there.
So that's relevant to both parts of D.
The conflict with the development plan is relevant to 11C because that says if you've got a development that complies with the development plan, then it gets an extra push on the presumption. But so there's a clear conclusion on conflict with the development plan taken as a whole, development plan overall. Then in 72, this is where we turn to paragraph 11D. The inspector notes to begin with that we're in this situation because there's not a 5-year housing land supply, and that's the third line. Then fourth line considers the first leg of 11D and reaches the conclusion at the end of 72 would not provide a clear reason for refusing permission. So that's not engaged. And then 73, and this in my submission, the three sentences are almost three different steps. So the first sentence of paragraph 73 answers the 11D2 question. It says, moving on to the second leg of paragraph 11D, the adverse impacts of the proposed development and the conflict with the development plan that arises from these adverse impacts would significantly and demonstrably outweigh the benefits. That's the 11D2 question answered. The next sentence, material considerations, would not indicate the proposal should be determined other than in accordance with the development plan. So that's answering the section 38.6 question.
Yeah.
And then the third sentence is really just the decision in a nutshell, summing it up in terms of the actual impacts. So that first sentence does answer the 11D2 question. And what the inspector there does when weighing the adverse impacts of the development in the 11D2 balance, the inspector took into account the development plan conflict arising from those impacts.
Yeah.
That's an example in my submission of where certain impacts in the 11D2 balance are reinforced because those impacts sound also in development plan conflict. As I indicated earlier, harm to the setting of the conservation area only conflicts with the NPPF policy, but harm to the setting of the listed building conflicts with both the NPPF and the development plan policy. So standing back and looking at this in my submission, we've got an inspector reaching clear conclusions on all the necessary elements, compliance with the development plan, 11D2 question, and indeed the 11D1 question, and the overall section 38.6 balance. So no element of it is dispensed with. None of those things are conflated. Their separate conclusions are stated on each of them. All that happened here is the inspector had regard to development plan conflict when striking the 11D2 balance. And in my submission, that is not an error of law. And it is exactly what the appellant's planning witness said in his evidence as well. He did the same thing. Took into account policy conflict in striking the 11D2 balance. And I'll just give the court the cross-reference to that so that we don't need to go back to the supplementary bundle, but that's supplementary bundle, tab 3, page 26. The court can see the appellant's planning expert taking that policy conflict into account when striking the 11D2 balance. That is not objectionable on my submission.
Right.
So that only leaves ground 9. I'm conscious, my lord, of the time.
Yes. Well, don't embark on that because clearly we're not going to finish straight away. You've just got to deal with paragraph 213.
My lord, that's right, yes.
Excuse me. Fine. And then reply. Right, so we should comfortably finish in good time this afternoon. So we'll come back at 2 o'clock.